Please get your people together. All right. Welcome everybody to our Ethics Committee meeting this morning for this quarter. I want to start off first with introductions because we do have quite a few new advisory members and we have quite a few new members. So I would like to do some introductions if we could. And I'll start. Dorothy Hairston Mitchell. I am a district court judge out of Durham, North Carolina. I am your Ethics Committee chair this year. Super excited about that. I have been on the council now I'm in my 8th year. I'm getting pretty sad because next year is my last year as a council member, or counselor. So that's me. We'll go this way.
Good morning. I'm Davis Poisson. I'm the vice chair working with Dorothy, and I've been on council at least 4 years. Ethics the whole time. I'm an attorney out of practice out of Wadesboro with Poisson and Bauer.
I'm Julie Bell. I am a district court judge here in Wake County. I've been on the council 5 years. My first year I was on grievance because I wasn't a judge, but I've been on ethics since.
I'm Patty Head, formerly from Raleigh, now from Lake Gaston, North Carolina, Littleton, North Carolina, actually. And this is my 4th year as a public member of the council.
I'm Julia Ambrose. I'm a new member of the committee. I've been an advisory member for about 2 minutes. I'm here in Raleigh with First Pierce, and here to watch, learn, and participate.
I'm Takia Lewis Blaylock. I've been on the council for I don't know how many years. I do this every time. I can never remember how many years, but that many. I practice in Hartford, Northampton, Halifax, and Bertie. Yes. Yeah, Halifax County. Yes. Excited to be here this morning.
Good morning, I'm Jeff Foster. I'm a Superior Court judge in Greenville, District 3, and I'm completing my first year as counsel.
And I'm Evan Rawls, and this is my 9th year, and I'm about to be released into my natural habitat.
Kevin Kiernan, representing the 5th District, attorney out in Clinton and Jacksonville, finishing 6th year.
I'm George Cleveland. I'm a district court judge from Winston-Salem. This is my 7th.
Good morning, Jamie Hinkle with Smith Anderson here in Raleigh, new advisory member.
Good morning, Christina Pearsall. I can't remember if it's 3 or 4 years. I'm a transactional real estate attorney in Greensboro, North Carolina with Shelbright.
Morning, I'm Bill Rogers. I'm an attorney in Concord, the 25th District, and family law practice, family financial mediator, superior court mediator. I'm finishing the 2nd year of my first term on the House.
Scott Basil. I'm a new member of the advisory committee. Practice here in Raleigh at Parker Poe and do mostly class action litigation.
I'm Stacey Cordes. Sorry, I don't have my name yet, but I'm from Charlotte. I'm a Cordes Law, I'm a bankruptcy attorney, bankruptcy debtor creditor, and this is my 3rd year as an advisory member to the ethics.
I'm John Whitey. I'm a bar counselor from the 1st Judicial District, which is the 7 counties in the northeast corner of the state, and this is my 2nd year on the committee.
I'm Martin Scott. I'm a general practitioner down from Columbus County area, southeastern North Carolina. I'm with Tara, who's there as well. And so I think this is my 2nd year as well.
And I'm Tara Gore. I'm from Whiteville, North Carolina. Practice criminal defense in Columbus, Bladen, Brunswick, and Robinson counties. And I believe this is my 4th year.
I'm Nancy Grace. I'm a family law attorney with Wake Family Law Group here in Raleigh. And this is my 2nd year as a bar counselor and on this committee.
I'm part of the Family Law Row here. I'm Heidi Bloom. I'm a family law attorney at Wyatt Robbins in Raleigh. I am working on a life appointment for the state bar. 9 years as a counselor on grievance, and finally came over to the bright side, and I'm an advisory member on ethics.
I'm Liz Hill. I live in Raleigh and I'm in-house counsel for HCA Healthcare, and this is my 3rd year on ethics.
I'm Warren Savage. I handle claims against family lawyers at law. I've been my last year as a counselor from White County and been on this. Prior to that was advisory board number 2.
Jay Benoit, I'm from Wilkesboro, in the Wilkes, Ash, Allegheny, and Yadkin district. I was an advisory member, and now this is my second.
I'm Gina Morris from Mecklenburg, and I am sitting between my best friends from law school. But I practice family law in Mecklenburg with James Springfield, and I'm in my 6th year.
I just learned a little more about Jay.
His rates are going up.
I'm Bill Powers. Yes, I graduated class of '92 Campbell. Very nice of you. I'm proud of you, friend. And I'm from the great state of Mecklenburg, and I'm an advisory member.
I'm Craig Lynch. I practice commercial real estate law in Charlotte. This is my 2nd year on the bar council as a bar counselor, and I'm sitting next to my best friend who is at a law school.
Thank you, Craig. Ellen Murphy, I'm an advisory council member. I think this is my 3rd year, and I teach professional responsibility at Wake Forest. And I used to practice law with Jamie Hinkle, and I'm glad he's here.
And I'm Ashley Campbell at Legal Aid, and I'm a counselor from the 10th. And I'm joined today by my daughter, Caroline Campbell, who is 12.
I'm Wayne Michael. I'm a
County Compliance Department. Had that position for about 3 months. Oh.
I'm Kelly Young. I am the new Pleasant County Field Auditor.
Yay. All right. Is it somebody? Yes,
Yeah,
good morning.
I'm Lincoln. I came in a little late. I'm District Court Judge in Surrey and Stokes County, 3 years on the bench.
And do I see Alice way back there too? Okay, yes.
Hi, Alice.
Yes, Alice.
I'm Alice Mine, I'm a husband.
Never that.
Hey, I'm Anna Hamrick. This is my last meeting, so I'm in Hasbin as well, 9 years from Asheville. And I was one of the first people audited over here. Our firm got audited when she first came on. Nice job. I'll miss everybody.
All right, I think that covers everybody. All right, thank you, everybody, and welcome to our new members. We are great. We are so glad to have you, and we know that you're going to learn a lot, and we appreciate your comments, feedback, and your work, because you will work on some subcommittees in this committee. All right, I'm going to read the Ethics Act statement. Members of the committee are hereby advised of their duty under the State Government Ethics Act to avoid conflicts of interest and are instructed to refrain from participating in any matter coming before this committee with respect to which there is a conflict of interest. So if you do have a conflict, you can let us know now. You can let us know at the time you realize that you can. All right, so we're going to move through our agenda. We start with our special agenda items, administrative items, report on trust account funds.
Kelly and I both have voices that carry, but let us know if you can't hear us. All right, so I'm here essentially to introduce Kelly as my successor as field auditor. She took the reins in August, and she prepared her first quarterly meeting report, and will give the reports and the summaries going forward.
Not nervous. Good morning. So the audits for the 3rd quarter of 2024 were conducted in Bladen, Buncombe, Chatham, Cumberland, Durham, Harnett, Johnston, Lee, Mecklenburg, New Hanover, Orange, Pender, and Wake counties. It's a lot. So we did one audit each in Chatham, Harnett, Johnston, Lee, and Pender counties. 2 audits were conducted in Bladen and Durham. 3 audits were conducted in Cumberland County. 4 audits were conducted in New Hanover. 5 were conducted in Buncombe. 6 were conducted in Mecklenburg and Orange, and then 17 were conducted in Wake County. The two most common rule violations were 34% failed to escheat unidentified or abandoned funds, and 26% failed to provide a copy of the bank directive regarding checks presented against insufficient funds. Based on the geographical plan for 2024, audits for the fourth quarter will be conducted in Alamance, Davidson, Polk, Lenoir, Mecklenburg, Moore, Pitt, Union, Wake, and Wayne counties. And that's all I have to report unless you have any questions. Sir?
Is that, are we showing progress that the top two violations aren't monthly, with the reconciliation stuff, things like that?
For this quarter.
Yeah, the trend has to start somewhere.
Right. Very good. Thank you, ladies. All right, report on ethics phone calls during our prior report. Oh, my word.
I have no idea. Hello.
Okay, we need an introduction, please.
I have no idea who that is.
Okay. I'm a little distracted right now.
I can't tell who you are though.
Elizabeth Johnson.
Is that Elizabeth?
Really?
That's fantastic.
All right. We definitely need to get that out.
Okay, I'm sorry. So for the new people. For the new people, one of the things I do is keep track of how many ethics inquiries Nicole and Brian and myself answer each quarter. And so for the last quarter, it was 1,195 inquiries that we answered, and that's pretty high. And the top four were pretty typical. The top subject matter is conflicts, which is always number one. Second was about confidentiality. Third were advertising questions, and fourth were trust account questions. So we had a good busy quarter.
All right, any questions? Thank you so much. All right, Brian, report on CLE ethics presentation during the prior quarter.
I'm just gonna say, I love y'all. I love this. All right, prior quarter CLE presentations, you see in your materials that staff had 14 different presentations. You can see there's a variety of topics that we cover. So once again, if you all are part of any organizations, district bars, associations, anything like that, and you need a CLE presentation on ethics, you can let us know. We'll try to accommodate what we can.
Any questions for Brian on those CLE presentations? All right, we'll move to our subcommittee reports, starting with our inquiry of Raby. Fee agreement requiring payment of estate planning lawyers' future legal fees.
So that's me. I got here early today, this morning, to work on my notes, and I was locked out of the computer for the whole time. So please bear with me, and I know that Ashley will cut any slack if I forget to mention something, but this inquiry has been around for a long time now. The subcommittee has met several times, and we believe that we finally have a proposed opinion that is ready for publication. As you may recall, the inquiry arose when a law firm wanted to add a clause in its estate planning agreements that would require clients to agree that if the firm's lawyers were required to participate in any legal proceedings related to the estate planning after the client's death, like testifying in court or responding to discovery, the client's estate will cover the firm's fees and expenses at the current hourly rate at the time of the proceedings. The firm was considering a specific fee provision that they had been given, and that specific provision is included on the first page of the opinion. We originally drafted an opinion that stated that the proposed provision was not permissible because it did not comply with Rule 1.5. For background, Rule 1.5 provides that fees can't be clearly excessive and they must be explained clearly. And we found the problem with the proposed clause is that it doesn't exclude situations where the lawyer's work product might be an issue, and we felt like charging for that would be clearly excessive. And it's too vague because it doesn't specify the amount of the fees or how the fees might change over time. So the first draft kind of stopped there, and we got a lot of fees presented to the full committee. We got a lot of feedback from lawyers, particularly family law lawyers, set out in the opinion that the provision must be limited to situations where the firm's work quality is not under challenge. The contemplated fees and expenses must not be clearly excessive. The terms of the provision must be clearly communicated in a written fee agreement, and the client must consent to the provision. The opinion specifically emphasizes that the clients need to be made aware that the fee provision could result in future charges and that the rates for these services might increase over time. In order to keep the fee provision from being too broad and vague, which was a problem with the initial provision, the opinion recommends safeguards for any rate increases such as caps or adjustment clauses. We included in the opinion a proposed provision that we feel complies with Rule 1.5, and you can see that pretty much on the last page of the opinion. And this example allows for a 3% annual increase, and that was just a number that we picked. That's not saying that that's the only percentage that you could use or that you have to use per annum above the law firm's current rates, where, and there's a couple requirements in here that we also feel like makes the provision more limited and more clear, where the law firm is requested or authorized by the client or the client's estate to participate in these proceedings or provide documents, where the law firm is not a party to the proceeding, where the quality of the law firm's work is not in question, and that any fees and expenses shall not be clearly excessive, and that the law firm shall make efforts to minimize the time, costs, and expenses related to such a request. And concludes that this sample language is not the only language that can use. It's just an example, but it sets out what we think needs to be included in a provision for it to be acceptable. And basically, it needs to be limited. Fees and expenses can't be clearly extensive, and the main thing is the terms of the fees must be clearly set out and clearly communicated and consented to by the
All right, thank you, Suzanne. Ashley is
the princess.
Yes, Princess Ashley.
So I would like for the minutes to reflect my deep commitment to the gravy subcommittee that I would show up in this get-up. Caroline and I Hermione and I have a Halloween contest to participate in, so we'll have to leave after the report. I would just ask if you were on the committee, if you could just quickly raise your hand. This has been a really great group who has worked through a lot of difficult issues around this, and it was previously led by Gina as well. I just want to acknowledge she did such a great job. So I just want you to know a lot of thought and work has gone into this, and I think that it was the right composition of people on the committee with the right backgrounds and skill sets to really think through the issues. I'll caution you to make any changes to it. Please don't send it back. And this is my last meeting, so if you send it back, you have to have a new chair. So, and I just want to thank Suzanne and Brian too, who've done such great work on this. Thank you so much for your support.
Thank you. Does any of the other members of that subcommittee, would you like to give any comments?
We've talked about so much in the subcommittee, we don't talk anymore.
All right, do we have a motion?
So moved.
Second.
For.
What's the motion for what?
Just move in general? Okay, so, to publish, motion to publish? All right, do I have a second?
Second.
All right, any discussion? Anybody else want to give any comments? With that like.
I have
nice
one comment, is
caution?
not to send it back.
Okay, I swear.
When I first read it though, when I read the answer, the first opinion as drafted, no, I read it as the rule as drafted and not that provision above it. In other words, if it said as drafted,
Gotcha.
do you see what I'm saying, Suzanne? Yeah. Because when I first read it, I thought, oh, but are we changing the rule? And so, right?
Okay.
Yeah, I see what you're saying.
Yeah.
I can make it a little.
That's
We
it.
can- Yeah, we
That's
can
it.
change that introductory kind of
Yes,
answer.
so,
All right.
I love it. I love it.
Well, you won't see him. Do not call on him.
I think I have
Well, there's the D at the risk of crossing Hermione and getting bonded by this, I mean, this bothers me in the sense that this is like normal people who get records subpoenaed and have to actually comply with court orders don't get paid for that, don't get paid to charge that. There are rules and statutes about paying witnesses. And I'm sure this subcommittee, because with a couple of exceptions, it was a great subcommittee. But, I guess y'all looked at and thought about all of that crap, but it just really bothers me that we're gonna say it's okay for lawyers to have a different set of rules than like architects. I'm not sure I understand the rationale. This is just part of what you sign on for when you decide to draft something. And lots of us do litigation where there are trust documents and wills and all this kind of crap, just like they do with real estate people. And if you have a dispute over a boundary, you don't get to bill that fee into that. I don't know. I'm just bothered. And I get to be old and bothered, and y'all can kick me to the curb right now, so that's fine, go ahead, but I'm sure y'all looked at all that crap, but it made me, it's one of those things that, we all have those hairs back there, and it sort of rankled.
Well, I did want to say that, we did do a lot of research, and what we learned is that law firms are already using this. It's very common.
Yeah.
It's a very common practice, and we got examples from other firms of provisions that they use, and that was part of what we used to come up with the provision that we did come up with. And South Carolina has already addressed this. They issued a very, very short opinion in 2023, but it said that this is permissible, and that was the only ethics opinion we could find. But what we found was that it's already being done. It's already kind of accepted practice.
We don't, since we don't draft any of this crap, it's not a real problem for me.
Well, I feel like we'll publish it and see what happens, like we did with the criminal discovery.
Definitely.
I won't be here then, so it'll be great.
Any other comments or discussion? Oh, yes.
I agree that I don't like it. The only other profession that gets paid are medical doctors who testify, and that's just because they've got a better lobby than we do. There's no logic for a treating physician to get paid to testify. But that's the way it is. I'm not opposed to publishing it, to see where it goes. I think that's the way to proceed, is to publish it and see what happens.
The original fee provision that they were looking at was provided by the American College of Trust and Estate Counsel, which is a pretty good, I think, reputable group.
Who's looking after their own?
Yeah.
Their own.
That's true.
Interests.
But so, anyway.
Anybody else? All right, we're ready for the vote. All those in favor of publishing this inquiry or this opinion,
language that is prejudicial to the administration of justice. So what I'm talking about is unsolicited language in the notes that speaks to the merits of the underlying case versus the DA setting the court calendar and letting the court know why we're here on that the defendant had been called and failed 4 times. And so it had been called and failed 4 times. And so we talked about that several times. Ultimately, we came down to that if we're going to include examples for the DA, we should also include examples for the public defender. So you see in your materials an example of a public defender including unsolicited language that can be prejudicial to the administration of justice. So the the subcommittee agreed that we would add some language for the public defender. We also talked about adding language that if a local rule allowed for lawyers to include this unsolicited, or I guess it would be unsolicited, if the local rule allows for the lawyers to include additional information other than the reason why we're there in court, then that too would be allowed under the guidance. So the guidance was amended to include that if the local rules allow for the DA or the PD to include information. The Odyssey eCourt system currently is the notes feature on the Odyssey eCourt system is currently only available to members of the district attorney's office and members of the public defender's office. Lawyers who are privately retained by defendants don't have access to these notes. So the guidance recognizes that private lawyers don't have access. The guidance was also changed to include that it doesn't only apply to members of the DA's office or members of the public defender's office, but all lawyers in case the Odyssey system is later changed and allows privately retained lawyers to have access to the notes. That's what we're doing.
all right, thank you, Nicole. Judge Bell.
I would say Nicole did a fine job, and I believe it's ready to, for a vote regarding publishing.
Well, we're not going to publish.
It's for,
that's guidance, okay. It's guidance. It's not a rule.
The
It's not a rule,
intent,
got it.
right, yeah, the intent is to distribute this to AOC, Conference of DAs, Conference of Public
Then
Defenders.
I think it's ready to be distributed, in my opinion.
Yes, sir.
I just have one question. Is there a similar thing for the ECMF system in federal court? Is that, just so it tracks the ethics?
We have not, we haven't addressed that, and I don't know that, I haven't been in that system in a couple of years. So I don't know if there are similar notes functions that you can attach to, like when you file your motion to dismiss, if you can put comments in there. I don't recall the last time I uploaded, but that was probably a decade ago.
Yeah, I didn't know. I know the criminal ECMS system, I don't do criminal law, is different than the one I use all the time in civil. And I just, all I was going to say is that we have guidance, I would think we want it to track so that a lot of criminal attorneys that do criminal law are do it both in the state system and in the federal system, and they have very different e-filing systems.
Yeah, this one is only addressing the Odyssey system.
Thank you for that question. Yes, sir.
I would note that not only is it retained counsel that doesn't have access to it, but private appointed counsel in conflict cases do not have access to it. So all of our appointed attorneys are not even on the same footing. The public defender's office has access, but private appointed counsel does not have access. And I think use of the system violates the rule as it is, and we're trying to massage the rules to comply with the computer system. And I just think use of the notes function probably should not be allowed.
It should be the other way around. The computer system should comply with it.
I'll note that I am not in an Odyssey district yet, so.
I think the point is well
District's already
taken.
on it, might just have something more to add.
Well, the
That's a great
guidance
point,
does, yeah, the guidance has been changed to apply to all lawyers, and not just DAs and public defenders. So hopefully, privately appointed lawyers will also.
But they don't have access.
They don't have access
They can't
now.
read what's been put in there.
So
I'm
that,
not worried about what they're putting in, I'm worried about what they can't read.
So the guidance says that lawyers can't put that information in. They can't put in the unsolicited language. Because, right, not everybody has the same access.
For that matter, the same goes for pro se.
exactly, that's what I'm about to say.
Pro se,
Taking it a step further, the pro se persons can't even see even more. Yeah. So I just want to remind everybody or tell those that haven't been here that this subcommittee included various members of our bar. So public defenders, we had a chief public defender, we had private counsel, we had a district attorney, judge,
Somebody from AOC.
ALC, I want to say
Judicial
from
standards.
Odyssey, judicial standards.
Yeah.
So
We had all stakeholders.
very good group of folks, everybody weighed in, it was a lot of discussion, about this, kind of going back and forth. Yes.
Sorry, I was curious, was there anybody from the company Tyler Technologies in that?
No, we only had a.
AOC.
Okay, no, it's fine, I didn't know if they
Yeah.
had any.
And that was the very first meeting we had, a representative from AOC come and kind of talk about the system, so we understood what we were talking about. It was one of the, we received, as you can imagine, when Odyssey launched, we received a number of different complaints or inquiries. And we refrained from issuing anything really formal, even addressing much of anything, because we didn't understand how the system worked. And frankly, I think some of the folks that were first using it may not have understood exactly how it worked. It was a brand new computer system. Of course, there's going to be a learning curve. But as time went on, this became a thing where, and I think what prompted us addressing this was not just hearing comments from lawyers, but also from judges, particularly judicial standards said that they received a number of questions from judges saying, I'm seeing some information in this part of Odyssey, and I don't know if I'm allowed to look at it. I don't know if I should admonish the attorneys or not admonish the attorneys, but address the attorneys that put stuff in there. And that's where it just kind of evolved into this larger discussion about ex parte communication, what is and is not, what is and is not appropriate in terms of just unsolicited information, but also, it was a larger conversation on a very narrow idea, a very narrow part of Odyssey. But the hope is that this will be helpful to AOC when they train folks on Odyssey, the Conference of DAs, Conference of Public Defenders, that everybody just is put on the same page. It's almost like if we had to summarize this, it'd probably just say, think before you type anything in there. Plain and simple, but nevertheless.
Yes, ma'am.
I don't want to open a can of worms, I'm just very curious, how does a local group get around the ethical issue in this regard? I just, because I like everything as it's written, I appreciate all the discussion we've had, but I still think the local rule, I don't know, how does that make it right?
I mean, I think that kind of comes down to the question of, the general prohibition on communicating with a judge or providing information unless authorized by law. That if there's a local rule that's adopted by the judiciary in that district that says lawyers may put this limited information, it's kind of a similar thing if I don't know, if there's a local rule that says, all litigants must provide written briefs by email to the judge, even though that would be, if you just decided right before your hearing on Monday, that weekend, you sent a brief to the judge by email, if there wasn't any sort of request for it, it's kind of an unsolicited
Information, it's the task notes, that it should not include this information, it's the task notes, that it should not include this type of communication. Right.
Specifically tailored.
Exactly. Not opening it up more.
No, I was just gonna say, in the meetings where we found out was that different jurisdictions was doing different things with Odyssey. That's one of the tough things about Odyssey is that there's no one blanket way to use it.
Thank you very much. Nicole, you want to- Inquiry of Savage, obligations related to notice when lawyer leaves a firm.
Thank you, Warren, for this inquiry.
She uses that term, thank you.
I know how she meant, from the heart.
Yeah. Again, I apologize, my notes are a little bit scattered, but Craig is just on top of everything, so I know he'll fill in. First of all, it's got news requirements when a lawyer leaves a law firm. And the fact pattern is a lawyer's leaving a firm, going to another firm. He asks the firm he's leaving for contact information for his clients so that he can let them know that he's leaving the firm and where he's going to be. The firm says there's no requirement in the rules of professional conduct to give notice to clients, and we're not giving you that contact information. So that was kind of the background. And like I said, there's 8 inquiries in here. Some of them, I think everybody kind of knows what the answer is. We just included it, so I don't know that we want to go through all of them in depth. Like, okay, so the first one is, do the rules of professional conduct require that notice be given? The answer is yes. I don't think there's any issue with that. Clients that are going to be affected by the lawyer's departure need to be, the duty of communication, Rule 1.4. They have to be reported, and it talks about significant client, contact means meaningful interactions with the lawyer and the client. And it goes on to say lawyer who merely prepares one research memo without any direct client interaction does not meet the threshold, and so that is not somebody that would have to be given notice. It does conclude that opinion by saying that if you're not sure whether a client should get notice, they should get notice. So always err on the law firm, and the lawyer needs to err on the side of giving the client notice. Inquiry number 3, who must send the notice? I think everybody's probably knows the answer to that. Both the lawyer and the law firm have a joint responsibility to make sure these clients are informed. Our preference is that a joint letter is sent out. The lawyer and the law firm get together and decide what they're going to say, and they send out one letter. However, if they cannot agree on a joint letter, then the lawyer and the law firm each has a responsibility to make sure that the client is informed. And relevant part of the answer to inquiry number 3, which is relevant to the initial fact pattern, is it says, we say that a law firm cannot prevent a departing lawyer from notifying affected clients. Specifically, the law firm may not restrict the departing lawyer's access to current client information. And that is a question that we get a lot. Lawyers will call us and say, I'm leaving, and they won't give me this information. They have to give them that information, is what this opinion says, and I think that's always been the rule. Inquiry number 4, this is one that David Allen really liked. It asked, may the departing lawyer inform his clients that he's leaving before he tells the law firm? And the answer is maybe. There's no rule.
I'm not going to answer that.
Hold on. There's no rule of professional conduct requiring the departing lawyer to inform his law firm before he informs his client. I mean, yeah. There's no rule that says he can't inform his clients before the law firm. But it is in the best, the lawyer that's leaving needs to look at what's in the best interest of his clients. What's in the best interest of his clients is going to be to tell his law firm and for them to cooperate, and for there to be a smooth transition when this lawyer leaves. David Allen wants everybody to know that there's other rules that they need to look at. There's legal, there's employment contracts, fiduciary, there's other legal issues that lawyers need to be concerned about, and we reference that in this opinion, but we don't talk about that because that's outside our purview. Under the ethics rules, there's no specific rule saying that you have to tell your law firm first, but what we've decided and what we say in this opinion is that you should only tell your clients before the law firm in very extreme circumstances where that law firm has a history of shutting lawyers out when they leave, ushering out the door, shutting their computer off. there has to be some reason that the lawyer concludes it's in the best interest of my clients to tell them first. Otherwise, the presumption is it's in the best interest of the client to tell the firm first, so everybody can work together.
Good.
Inquiry number 5, when should the notice be sent? As soon as possible, under the circumstances, is what the answer says there. They need to, ideally, the clients will be told with enough time to decide, think about it, decide if they want to stay with the firm or go with a law firm. Sometimes things happen really quickly and there's not a ton of time, but as soon as practical, as soon as feasible under the circumstances, the client should be informed. Inquiry number 6, what must be included in the notice? This is what people normally talk about the choice letters when they call and ask about it. The main thing that needs to be included in the letter is inform the clients of the choice, the options that they have, and that's generally stay with the law firm, go with the departing lawyer, or get completely new counsel. So in an ideal world, they would get those 3 choices. Sometimes those 3 choices are not available. If the lawyer is leaving to become a judge, he can continue to represent them. So in that case, the client should be given the 2 choices. Stay with the firm or get new counsel. Sometimes the firm doesn't have a lawyer who does that kind of business anymore, so they can't handle it better. So in that case, the client should be told you can go with the departing lawyer or you can get new counsel. And then we do talk about avoiding cherry picking of clients when a lawyer is leaving a firm. And so the fact that the lawyer is departing a firm should not be a time when the lawyer and the law firm look at the clients and say, well, I want this one, I want this one, I want this one. And so what we decided is that if both the departing lawyer and the law firm have the means and there's no conflict, they each could continue to represent the client that they're already representing. That choice should be presented to the clients. You shouldn't be able to say, oh, I don't want that one. So, because sometimes nobody wants it. That's not the time where you get to kick the client to the vote. And then the rest of inquiry number 6 goes on and talks about it should include status of the matter and fees, if they leave, any fees that they would owe, and then what would happen to the firm is not to disparage. The firm is not to disparage the lawyer that's leaving. The lawyer is not to disparage the firm. But there are situations such as those set out in 213 FEOA, and that's referenced such as those set out in 213 FEOA, and that's referenced here, where it would be unfair to not tell them. Keep this in the opinion, I don't know. It makes it long. Keep this in the opinion, I don't know. It makes it long. You can just have this as a resource, but currently it is in the opinion. So I can hear your thoughts on that. Inquiry number 7 is departing lawyer entitled to current client, yes. And then the inquiry that got probably the most discussion is inquiry number 8. And that asks if the departing lawyer is entitled to a complete list of all his former clients. Some members of the subcommittee felt like requiring the law firm to give the departing departing lawyer a list of all his former clients was over. That feels like yes, the law firm should give the departing lawyer a complete list of his former clients, not to the firm, not to his new firm, but to the departing lawyer, so that the turn over that list. But there was a lot of discussion, and that's why there's 2 options. Turn over that list. But there was a lot of discussion, and that's why there's 2 options presented here.
Can I ask a question about that last piece that you spoke about? Because I was thinking exactly what you just said, that how is it burdensome, at least in the first option, if they are saying they should provide a list to that departing lawyer of the persons they think would be a conflict. If they have to go through the list anyway to create that list, I mean, they're already, did y'all have any of that discussion?
We had a lot of discussion.
That seems to be more work to have to go through a list to figure out which ones
Well, I would like the committee members to discuss this because I know which one I think is correct. I was not in the majority.
Okay. So, great. What's
But it
up?
was a fairly large minority, wasn't so clear cut. That's why you have two separate options here, similar to what we did when we dealt with the issues of a certain common family in Winston-Salem earlier this year. But you're absolutely right. I think I certainly have access to every client that I've done work for at my firm. I know it's a big firm with a very robust computer system. Others may not have that resource, but I can access that. I think determine what ought to be disclosed. And so I was somebody who was in the camp of option B. And again, it's something that we thought was important for purposes of protecting the public. One of our committee members, our grumpy old lobster boat captain, let's just call David Allen. But he had a great example of something that happened in his own experience where, it's hard to make anything bulletproof. And there was something that occurred that created issues for you, and I thought argued in favor of being over-inclusive of identification. So I'm in the same camp that Suzanne's in. I think I like the idea of kind of at least giving the departing attorney a complete list. And heck, I have a list that I keep. I don't need my firm to provide it to me. I already have it. So that's where I fall down.
But I did want to say, there is no requirement to do that now. So this would be kind of creating a new duty. And so that caused people some concern that we were creating this new duty through this opinion.
So I had kind of a question of that. It feels like there's an indirect duty though, because we have a responsibility to detect conflicts of interest. And I was not in the subcommittee meeting, so I didn't know if there was discussion of that, but the exception in 1.6 that allows disclosure of confidential information to detect these conflicts of interest and the general duty of every lawyer to avoid conflicts of interest, you can't avoid a conflict that you're, I guess, uninformed. And so I guess I don't know if there was any discussion on, maybe it's not a specific duty that upon departing a firm, the firm must provide departing lawyer with X, but I guess indirectly, I feel like the rules do require lawyers as a profession to, I guess, collectively and individually avoid conflicts of interest. And so how do you comply or how do you carry out that duty if you don't equip the departing lawyer with their list of actual clients that will cause a conflict should they take on a particular representation?
Attorney Grace?
I am in Brian's camp. I think the option 2 is the better option, and just from experience in a family law firm where, in a judicial district or in a county where you've got a husband and wife, and then you've got, there are a lot of potential conflicts in a small area in family law cases. And it is, in the past, we have sometimes had trouble when we hired new attorneys getting that list from other attorneys from their prior law firms, or from, that the prior law firm would give the list to the client. And it's really difficult then as the new employer to be able to meet your obligation, to be able to do, add it to your conflict system and do a robust conflicts check. So I think I agree that there's maybe not an explicit requirement, but I think there is an implicit requirement in having the tools that an attorney needs to be able to perform an adequate conflict check.
Yes, sir.
I was kind of jump on that. One of the things in my office, I want someone to staff to get the middle name, the date of birth, the other identifying information, because we do have clients, John Smith, Sally Jones. So what level of nature and extent of that information is provided, understanding that, does that include their last known mailing address? Does that include their email address, their cell phone numbers? Did they get the entire contact card? Because we regularly get people where they're either return or they have a very, very similar name. I had a client this last year where the father and the son had the exact same name, and the only way to discern was their date of birth. And we went back and forth, back and forth. So to what level that goes? Now, we have a computer system like where we can probably provide that information, but that's my concern, is how much information are you?
Our clinic and told that one of our law students was not able to provide a conflicts check material to his new employer. Because the firm with which he had worked in the summer would not release the name of the clients with whom the law student had worked. So this is real not only for lawyers.
Is that somebody? Yes.
Law firm. And so I'm not sure that law firm. And so I'm not sure that is going to catch the kind of conflicts that we're talking about here. Because if I have the list, if it doesn't get loaded into my new firm's conflict list, it may not disclose the conflict. And I think that's just giving it to the lawyer.
Right, I was going beyond just this particular question, because I think reaching back to some of the earlier opinions, I think it's a problem if a lawyer can't have a file for the past 7 years.
Yeah, I think
for
we,
the clients that particularly.
5 years, but I never got a copy of my file and we go back to the firm, regardless of whether the person that handled my case moved on. I didn't know that they moved on, so I had no idea it was the same person. But that's a conflict, and now everything is derailed.
The new firm to put into their system. And members of the subcommittee felt more comfortable saying, give the list to the departing lawyer because of issues of confidentiality and that type of thing. Saying, give the list to the departing lawyer, then the departing lawyer, and this is, it would only work in a scenario where the law firm sends out, here's who we're gonna represent, whichever. But it puts the duty on the departing lawyer, who's now at the new firm, to keep the names confidential unless he sees that there's going to be a conflict. So that was kind of a compromise because some people did not like the idea of the new firm having all that information.
Yes, that's great.
I don't think that's very practical. At the end of the day, just from an employer of a family law firm who hires associates, like I can't have 15 different conflict lists that we've got. I mean, we have one central conflict list, and the lawyers that we're hiring that might come from prior firms, we have to have that information in our conflict system, or else really our conflict system doesn't work. You can't do 15 different conflict checks with 15 different lawyers, and family law firms are small firms. I mean, imagine a much bigger firm. So I don't think it's practical to, I think it's fine to give it to the lawyer, the departing lawyer, but I don't think there should be any suggestion that the departing lawyer that somehow a breach of confidentiality for the departing lawyer to then provide that information to the new firm so that they can add it to their conflict system.
I'm just reporting.
Yes, Juan.
Yeah, I agree with that. I mean, to the extent that when the lawyer moves, he doesn't bring all his conflicts such to conflict with the new firm out of everything, right? The lawyer can be screened off. So that lawyer and their new firm can decide how to deal with the lawyer's former clients and how they deal with that. And I think we're going to get in the weeds if we start suggesting anything other than the lawyer is entitled to his list of his former clients when he leaves, period.
Leave it at that.
Leave it at that. He can deal with the firm, because some firms might want to know, so they can do it, but other firms, some other lawyers might not want it because switch firms every 2 years like David, and you can prosecute his best for himself. I mean.
We got a mismatch. Just want to be an example of this.
But I guess my point is, we can, I don't want
No, that's good.
to tie this up so much, because everything else about this is wonderful. I love it.
So with that, do you have any other members of the subcommittee that would like to speak or comment about it? Do I have a motion?
Can I make one comment?
Hey,
Yes, I had
I would be remiss if, I'm sorry.
I haven't been involved in this committee, the subcommittee. One thing that gives me some pause is what I've heard a minute ago. And I think Brian used the phrase implicit duty or indirect duty. I'm not sure what that means and how we interpret that. And I've obviously got wear a lot of hats here. I'm just putting on my old grievance committee hat. I'm not sure how I would know what an indirect duty is. My understanding is we prosecute and apply the ethics rules as written. For example, we can put aspirational duties or indirect duties perhaps in the comments, but we don't prosecute folks for that. We can put it in the preamble. We don't prosecute folks for that, but the notion of what's an indirect duty or an implicit duty, I would ask the committee to give some serious thought about that, because what I'm hearing a lot of is it's not in the rule, but we need it, we ought to have it, and somehow somebody's gonna figure out what we need to have, but another person's gonna say we don't need to have it, and that's gonna create some issues for the bar in terms of some grievances filed, and we say, we talk about it in the ethics committee, and there's this indirect duty or this implicit duty. I would ask us to think about being very specific relative to our rules, and if we need to amend our rules, we do that, but the notion of an indirect duty or an implicit duty gives me pause. I just want to put that in the room.
Yeah, and I think I may have spoken a little too softly. I agree with Ellen's comment that I think it is pretty clear, because the rule violation that we're talking about, if I put on my old prosecutor hat, it's the conflict of interest, the lawyer engaged in conflict of interest. And in proving that, if you're in a disciplinary case and some lawyer is saying, I didn't have a conflict because I didn't know I had a conflict, then we're going back to, well, you had this conflict from the former firm, and you had a duty to detect that former client conflict. And the only way that a lawyer is allowed to detect, if we're going to issue an opinion that says, no departing lawyer does not need to, or is not entitled to a list of the former clients, then that is kind of I think that sets up the pathway really for a lawyer who is charged with violating the conflict rules in a disciplinary proceeding to have some sort of legitimate defense, say you know who your clients were. So that's where I guess I was kind of saying that option 2, to know who your clients were. So that's where I guess I was kind of saying that option 2 is, I do agree, option 2 is the better, I think is the more correct statement. Frankly, I think option 1 is saying the same thing as option 2 in some ways, but I think option 2, it's not so much stating an implicit responsibility. The duty is to avoid conflicts of interest. Option 2 illustrates how a lawyer carries out that responsibility to avoid a conflict of interest by being given the information to detect those conflicts of interest.
I did want to say, to Todd's point, I think there's at least 2 states that have a specific rule about this.
About providing the list.
I think we can also put in the quote that Ellen provided in the second option, so it's very clear that it's not implicit. I think it's pretty direct.
Yeah.
But one thing before we stop talking about this, and I don't know if it's going back, I wanted to know if any, besides inquiry 8, if anybody that read the opinion had any issues with any of the other inquiries.
Suzanne, I didn't have an issue. I loved the sample language. I know it's long,
I like
and
it
I
too.
get that, but I think it's wonderful.
Okay.
Really,
I
It
think
creates a
we
default
appreciate it.
position.
Yeah.
Start there, and if they want to go off.
Yeah.
Yes, sir.
I don't want to get into the weeds. I think someone said it clearly. I guess I'm thinking does the client have any say in the transfer or non-transfer of the list? For example, I'm not a big firm. We've been hired by clients who said, I don't want you to ever tell anybody that we hired you. Anybody. The client says, I don't want you to tell anybody, then I think I have to abide that client's instructions. And so if I leave the firm and I work on that case and I go to, big firm across the street, if the rule doesn't account for that, then how does that work? I mean, I would think the client would be able to say, Hunter Williams, you can't tell anybody that Todd Brown ever worked on my case, ever. And you can't tell anybody that you, the firm, worked on my case. And if I leave and I want to take that client with me and get that client on that list that we're talking about, does it go on there or not? Does the client have any say in that, in the transfer of my identity from one firm to another?
I would say it's a situation
I
that
think
arises.
you have to, the client cannot tell you not to obey his
Exactly.
professional conduct.
Right.
So at the end of the day, cannot tell you not to obey his
Exactly.
professional conduct.
Right.
So at the end of the day, I mean, if client says to you, I don't want you to tell anybody, you've got to say, well, I will.
Or I don't have the ability to represent this particular person, and I think that is, Nicole and I were just saying this, a person, and I think that is, Nicole and I were just saying this, that it is the responsibility to keep that confidential under 1.6, but the exception allows a lawyer to disclose to the extent reasonably necessary to carry out their duty, and I think that would be the thing where it's almost like a trickle sort of thing. Hopefully it's enough to say, I can't handle this one, I have a conflict, period. And if for whatever reason a court compels an attorney, I need to know why you have a conflict, then you might be in a different scenario. But I think that would be a really specific kind of case-by-case scenario that the opinion would not be able to address.
Yes, ma'am.
I have had that problem. After 18 years at one law firm, I went to a different law firm that was on the other side of lots of my cases. So I have revised my fee agreement for the 10,000th time, and it actually says in it that I will not take a position that is inconsistent with the rules of professional conduct, no matter what you want me to do. I mean, it's nicer than that,
Right.
but I think it is important that we let our clients know in advance of representing them, I will do everything I can for you, but I am not going to violate the rules of professional conduct for you, period.
To me, I think that would give you a defense, because you have the ability to say, my client instructed me not to do it. And I'm abiding the wishes of my clients, and if some judge or the bar tells me to do something else, fine, but I can't get prosecuted for what I agree with me.
Yeah.
Yes.
But I just think the point is, you gotta let everybody know, it's a problem. It's a quandary.
About a half a dozen times in my career, I've had this come up. And the first time I opened the file, the client's name was Client X. And this was a well-known case, statewide. And the next time it was Client Y, and several elected officials. Started running out of letters, and at least one judge, I had Client A. And so it's, if something happened to me, they would have Client X or Y or Z, but with no identifying information about the identity of the client in that file. Todd, to your point, you've got to respect the wishes of the client to not reveal or disclose that information. 1.6 really pretty much covers that. And so I think it's going to be, it'll be aberrational. These in 46 years of practice, half a dozen times. But nonetheless, I think that lawyers need to respect the wishes of their clients to not reveal or disclose their identity.
Lawyers didn't used to change law firms like they do now. I mean, these young people are changing law firms every couple of years, so this problem's going to get bigger and bigger going forward.
Yes, sir.
Just real quick, the list is going to the lawyer. That's what I'm gonna say. The list is going to the lawyer. If the lawyer knows his former client informed him to never reveal that he represented him, then to what Brian was saying before, and all the lawyer needs to say is, I got a conflict, period. If it comes up, every lawyer in a law firm, I don't know, matter whether it has 2 lawyers or 2,000 lawyers, is responsible for making sure that they are not putting their firm in a position that's uncomfortable by taking on something that, because of their change in employment, that they are, might take on something that they have a conflict on. So, you know, if he knows, he or she knows that they've got a former client that says they don't want anybody to ever know, and that presumably, if they were a former client and it was that type of client that said that to them, they would know that, right? They would know that they told them not to reveal that they had ever represented that client. So then going forward, they could, if that name came across their desk on a conflict check, they would know, hey, I got a conflict, screen me out.
And you screen yourself out.
And you screen, well, then you screen yourself out.
And that's why it's important that the list go to the lawyer.
To the lawyer, and the lawyer, it shouldn't tell his new firm if he's been told by the client.
One of the scenarios that Todd, I think, is referring is you get occasionally a matter comes in and they say we have a potential waivable conflict.
But to Gina's point, I do think perhaps we always need to consider modernizing our rules because practice law is changing very quickly. What I said, it may not be addressed, but if we need to look at rules that perhaps need to be tweaked because of the change in practice, and folks going from firm to firm, then maybe this body should look at that if they deem it appropriate. Sorry, I'm saying.
All right. Yes, sir.
I just want to make sure that we give credit to the members of our committee. We moved at light speed. There's no question about it. We had a bunch of meetings.
Greg made us meet twice, at least twice every quarter.
We have work to do. But think about it. We dealt with lawyers that went around the bend, dealing with law firms and lawyers who are at loggerheads and how to deal with those kinds of situations. At any rate, I'm really proud of the work we did, how fast we did it, and I think we got a good work product. I will say this to Todd's point and to one that David raised. It may be time for us to look at the 2013 FEO 8 again. Obviously, 11 years have passed. This is a tricky thing when you're dealing with an attorney who may have some issues in terms of competency to handle a matter when moving to a different law firm. And anyway, it's a breadcrumb. I'm not trying to put work on anybody's plate, but we may want to look at that and say, hey, we may want to have a little more comprehensive treatment of that issue.
So are we at a place here for a motion? It sounds like we've had a lot of discussion of informal consensus as to 1 through 7, right? But then 8 is where we have that, but then we had some good discussion on that. It seemed like maybe a consensus there, but I'm not sure. Is there a motion do I have a motion? I don't want to give my.
I think the purpose for today was to get a lot of feedback from y'all on that inquiry 8, and we got a lot of it, and so I think the motion would be to return to subcommittee.
I don't think it's a heavy lift, but I think we got a little work.
That sounds perfect. Okay.
So the language, the last line of the first paragraph of the second alternative, the option 2, where it says, first that the default is, yes, they're entitled to the list, but then, however, the departing lawyer has an obligation to protect this information and will only disclose. If there's a way to just word that differently, because it almost sounds like the default is not giving it to the new firm. And I think what I hear in this discussion.
To subcommittee, please say aye. Any opposed, nay? All right, going back to subcommittee. Yeah. Sorry. So I think this is a great time to take a little break. 5 minutes. 10:36 minutes.
The opinion provides that it is, Ms. Kozlowski, who is the director of DRC, she has participated in our subcommittee meetings. And she asked that we hold this, the proposed opinion so that she can meet with DRC, and DRC would then issue an advisory opinion that requires a lawyer mediator to withdraw from the mediation if the lawyers involved in the mediation want to include such language that no lawyer will be reported to the state bar. So the subcommittee agreed with that, and would like to, I let David say it, but we just want to give the DRC time to see if they come up with an advisory opinion that directs a lawyer mediator to withdraw from the mediation.
I think we asked Tara, and I think staff was really good to make sure she was included in the discussion, if they could do something about this before we get the rule, because clearly we knew what the state bar was going to say on this, and if there's a way to avoid this without, for instance, the mediator, because if the mediator has to withdraw, that puts the mediation and all the work that's gone forward, if they're that close to a resolution, is there some way to, whether a mediator, as opposed to having to withdraw, could just say, I can't, I can't communicate that, you need to withdraw that, we can't do that. If there's a way to counsel the lawyers as opposed to just automatically, shutting that down, it might be easier if the DRC had guidance for the mediator, but this ought to apply to both lawyer mediators and non-lawyer mediators, and that's just a problem. So we decided to give them a chance to deal with this. I talked to Tara recently. They did meet shortly after we met. They met in September, and I told her that I thought I could punt the thing till January, but that I was not guaranteeing that the state bar would hold off making this decision after January. I wanted to put a little fire underneath those guys, because we just don't need, some of these things have a long shelf life. And so she said she thought they could do that. So I've not heard back from what the result of that was. I do know it was discussed at their September meeting. They will have another meeting before we meet in January. So hopefully that will be done. So my recommendation, Madam Chairman, is that we send the matter back to the subcommittee and wait elucidation from the DRC. Chairwoman, sorry. I didn't use madam.
All right, so I have a motion to send this back to subcommittee. Is there a second? Second. All right, motion and a second. Is there any other discussion or any other members of that subcommittee that would like to comment? Yes.
Quick question. The main thing that concerned me about this, and we talked about this, is whether the lawyer could inform the litigants and the lawyers that the inclusion of that provision was a violation of our rules. And I think Tara's position was that constitutes legal advice, and we couldn't do that, which didn't make a lot of, I didn't think that made great sense as a mediator.
We didn't agree with that and didn't think that it was, but I don't think the subcommittee ultimately decided yes or no on that.
Yeah. That's an open question. I was hoping that they might clarify that, so it would be wonderful if we received that clarification before we finalize it.
I think that's what we're hoping, is that they'll give us a little more meat on that. That seems not to be the only option available, and so we may have to give them some guidance on that if they don't give us guidance.
Take it back to the committee and get further at it.
Awesome. Any other comments? All right, all those in favor of sending this back to subcommittee, please say aye. Aye. Any opposed, nay? All right, thanks. Now we're moving on to proposed 2024 FEO2, withholding criminal discovery in district court.
I'm going to take that one. So we published proposed 2024 FEO2 this past quarter and received comment. This is the opinion addressing withholding criminal discovery in district court. Essentially, wrote in the scenario where a ADA and a defense attorney may reach a plea agreement for low-level felonies that can be pled in district court, but in district court you don't have a statutory right to discovery, and so some of these some of these plea deals are struck for, I guess, what we've been told is, for the purpose of efficiency, that the DA will say, listen, I'll give you this deal if I don't have to go through all the steps of discovery. If you, and I, as a lawyer, actually participate in that type of negotiation, that type of agreement. And, it presented kind of a novel question. That's why we brought it to the Ethics Committee. The opinion basically says that as far as the prosecutor is concerned, yes, the prosecutor can engage in this type of offer, but the opinion reminds the DA or ADA that, yes, you have to comply with 3.8. You have special responsibilities as a prosecutor to provide exculpatory information. You have your constitutional requirements under Brady and so forth. And as far as the defense lawyer, yes, you can participate in these negotiations because you are, like many lawyers out there, you are a lawyer, you have another lawyer on the other side, and you can presume that they're complying with their rules of professional conduct. And I have to say that was some of this position in saying that, yes, defense lawyer, as long as you fully articulate it to your client, I haven't looked at discovery, and that's part of the condition of this plea deal. So I can't advise you on what the evidence actually shows, but you don't have a right, as we're sitting here in district court, to get that discovery. You know what you did, that sort of thing. But if it's true, if they have evidence, then this is a really good deal. Basically, the defense lawyer can participate in that negotiation, relying on the notion that everyone else is complying with the rules of professional conduct. And that was informed, I think, by my conversations with some defense lawyers. It said, yeah, sometimes that really is the best deal that I can get. That's the best way, and I don't want that taken away. And kick everything to Superior Court, even if it's a low-level felony. So we thought this was kind of threading the needle, but we received a lot of negative feedback, you can see, from the defense community. I have to say, and including from one public defender who used to be my roommate in law school, and who I called and said, tell me where the opinion is wrong. And I still haven't gotten a clear answer of where the opinion is wrong. I've talked to a number of folks, and I feel like the general consensus, and I think it's changed, if at all, to kind of satisfy the concerns that I've heard here. But also, is the opinion going to just be more problematic? And maybe there should be no opinion issue, even though this is already going on. And we were asked for an opinion on this. Maybe that was the wrong inquiry. So I think it should ultimately go back to the subcommittee for further discussion of these different comments, and perhaps with an invitation to those that offer comment to come in and articulate their concern with the opinion.
Were y'all able to have any discussion about this piece of the felony originating in Superior Court, therefore the discovery obligation, would it be in an original jurisdiction of Superior Court, therefore it does apply as a vote?
Yeah,
I think that was one of the.
Yeah, and we didn't. I think that was, and that was one of the concerns. And that's more of a legal concern. Whether or not there is an actual right to discovery, depending upon where the matter is being pled, where it originated. All that stuff is kind of a legal question. I think the opinion was starting in the spot of saying we're kind of presuming that the law, that everyone agrees on the law, that both sides agree, there's no right to discovery in the posture that the particular charges find themselves. And because anything beyond that, we would be getting into kind of a legal analysis and really fact specific. I think if there is something where, the ADA is misrepresenting the law and they're saying, no, you have no right to discovery, and the defense lawyer is saying, yes, I do have a right to discovery on these charges, that's a legal question that the opinion is not going to address. And I think they'd have to fight that out in court. But this is kind of presuming that there is no, I guess, right to discovery depending upon where the charges are presented for plea.
Yes, ma'am.
I mean, I'm so vindicated by these comments, I cannot tell you. I'm glad my defense bar brethren stepped up, because as a county, as a practicing attorney in a county that has H&I court, I think apparently we're in heaven down there in Columbus County because our judges say, hey, if it's going to be a felony plea in district court, the DA's office has to provide complete discovery. You're gonna say, hey, plead to drug paraphernalia, class 3 misdemeanor, we'll drop everything no discovery, sure, fine. But if your client is putting themselves out there to plead to a felony, then the protections associated with that, I believe, should attach. And the inquiry blew my mind because our judges in our area will never allow that to happen, to the point when we reject a plea offer in district court, our judges say, have you received complete discovery? The state says yes or no. If the state says no, then the judge says, I'm gonna hold off on your rejection because you need to be able to make an informed decision before you reject this plea offer, because our district attorney's policy is that it's not going to get any better. So, I mean, I feel like some people took the position of, oh, well, the client knows what happened. And I think that criminal law, like, our process does not work that way. We need to know what the state knows, when they knew it, who did it. We need to know what officers are involved. We need to know what confidential informants are involved. And I totally understand you saying, tell me where the opinion is wrong, because that's the issue I've had. But I think fundamentally it's a problem because you're putting the attorney in a position where they can't advise their clients. They can't give information to their clients, and they say, oh, well, good luck. We have to hope the prosecutor's been honest here. And just to be clear, I work really well with our whole DA's office. I think we have excellent prosecutors, and they take the time to read their cases and read their discovery and say, hey, here's the issue. And it bothers me so much that if I happen to work in another county, that prosecutors are either saying, oh, you know what, I don't feel like reading this yet, so I'm gonna offer, or I don't have the report back, or I don't, the officer hasn't even given me a report, but we can resolve this quickly with 2 years of probation and a felony conviction. Like, that's such a problem. And I think that the legislature allowed for H&I court, but they didn't change the discovery rules to jive with what H&I court requires. I understand that we are not the legislature, but I also don't think that we're putting defense attorneys in a tenable position. And, if I read this opinion and my DA's office reads this opinion, why would they bother to do anything in H&I court if we just told them they don't have to? So, sorry for my soapbox, but I was like, finally, people agree with me. I'm not that crazy looking at blah blah baby.
So is it a legislative issue more than an ethics issue?
Yes.
I think it is, but I also think that the issue that is, if we put this out there, it puts defense attorneys in a very bad position because there's nothing to catch. Like we were talking about earlier, how the e-courts notice issue is the trusting clause, and I feel like this is a continuation of that, because if we have people making plea offers, how do they know if there's a Giglio issue? How do they know if there's a Brady issue? And, they're responsible for knowing that and communicating that to us. And nobody's read the file, and we just all agree, like, yeah, this sounds like it might be bad. Let's resolve it real fast. And nobody reads what happened. Nobody knows if there's even a police report turned in. Like, I just think this is a very dangerous road. And I know that it sounds crazy if you don't practice criminal law, because I've heard over and over again, like, oh, well, your client knows what happens. And that's just it's not how it works, especially when you have small police departments who deal with the same people all the time. I have people who literally like court. In our counties, it has worked wonderfully because we don't have people with drug possession or, anything low level where they're sitting around in jail or out of jail, but their case is lingering in Superior Court for 2 years because it's not high priority. And so it allows us to resolve that in district court, but the discovery requirement is not attached to district court. So it's inconsistent.
But is it still a felony?
It is still a felony.
You still have to vote and all that?
And you can take a felony plea in district court. It just has to be a court of record. So we, in our county, and everything's different, but we have designated days where district court becomes a court of record, so you can take those felony pleas. And I understand there's probably 99 ways of doing it. That's just how we do it. I don't know if it's right or not. But if you have the exposure of all the things that the original intent was you're gonna go down for a felony, you need all these superior court protections. You've taken away those protections, and again, it's been a great thing for our district, but you can't throw everything away in the name of efficiency. And I think that includes the prosecutor reading the discovery, and if we have open file discovery, why can't the prosecutor then pass it on to defense counsel? Because it puts the defense attorney in a terrible position, which I'm very lucky never to have experienced, because that's not how we do it in my county. If my client says, what should I do? And say, I don't know. I don't know what they said. What do you think happened? I don't know. You think there's a CI who has blonde hair within a 10-mile radius? Like, I think it puts you in a very, they're trusting you to advise them, and it ties the defense attorney's hands and keeps them from advising.
That's what I'm thinking, this needs to be discussed in subcommittee, whether or not the opinion is even needed, because it sounds like the opinion doesn't change anything as drafted. It's just kind of preserving the status quo, or saying that as it currently is okay, but going and saying that you can't do this would be effectively trying to change.
Is permissible but not mandatory in district court, criminal court. The prosecutor in district court, criminal court. The prosecutors have constitutional responsibilities that they cannot wear, but there's usually a big rare, but there's usually a big benefit for the defendant. And Tom and I were talking about this earlier, because lots of times we get clients that are habitual offenders. And the prosecutor will offer you a plea without the habitual enhancement. And it's very beneficial, to the defendant. It's also my experience that the more discovery that gets put into the prosecutor's file, the worse it gets for the client. And that's true in state court and federal court. And in some situations, it's, be careful what you ask for, because you're going to end up with a much worse outcome. But we're asked for a very narrow question here on district court discovery. And what, because some people don't feel right, and it kind of rubs my fur the wrong way too a little bit, but I don't think we ought to expand the inquiry any further than this is the law, and this is, the prosecutors have this discretion to be able to do this, and they do have obligations. And if it goes back to subcommittee, I don't see any change in the opinion. Otherwise, we're legislating here at the state bar, and we're also giving guidance outside of the rules of professional conduct. And we have got to stay right in that narrow bandwidth of the rules of professional conduct. And so I see some risks trying to expand this, and we've seen this happen before at this committee when we send this back to subcommittee a few times, and all of a sudden, it gets bigger than it needs to be. And the times that I've seen that before, the full ethics committee has brought it back when a subcommittee goes outside the bounds. But my motion would be to send it to council for adoption, as opposed to send it back to subcommittee as an alternative motion. But I understand that people may need to vent and get this all out and have it fully vetted and understood why we're doing this. But it's correct as written, and I'm done. I mean, I know I was chair of the subcommittee, but I'm out of here. You're gonna have to appoint a new chair, and and maybe that's okay. But that's my opinion.
Can I just ask a question? Because I don't disagree. I don't think anything's necessarily going to change. I think the only issue we have is opinion or no opinion. Because I think Brian's opinion is wonderful. I think we've talked it to death. I'm not going to change my mind, but I understand it's more of an issue of this feels wrong. then the ethical rules say this is wrong. And I really do agree with that. I think the only other option here would maybe no opinion, so we're not leading the districts down a path where prosecutors are like, oh, I didn't know this was an option, and, just having unintended negative consequences. So I really don't think the opinion necessarily needs to be modified, but if we could send it to subcommittee for that analysis of should we do an opinion at all. But I don't know. I think we will never get a better opinion than what it is, and the issue is legislative, and I agree with that. But I also don't think it's our position to endorse it and say, yeah, best practice.
Kevin, don't let me speak for you, but is your concern that the opinion might give a lazy or unethical prosecutor cover?
Mm-hmm.
Yeah.
It absolutely is. And I think that in the districts where we have H&I felony court, it may change procedures in a way that is, I think ours is local rules. You get discovery within 120 days or it goes to Superior Court. Now, obviously, we're a more rural district. I understand everything's not on. But a lot of times it's like, okay, the police report came later, 6 months later, we do it at Superior Court, and not all that much has changed. So I think that, yes, I am worried that it's going to put places with a strong defense bar and a public defender's office who has nothing to lose. It's either going to bring H&I to a grinding halt because they're going to be at loggerheads, or it's going to make it so H&I court becomes a blank, everybody pleads guilty or else we're asking for active time, or just an example like that. I think that you did a better job voicing my concern than I did.
Oh, no, you've done an excellent job.
Can I-
Made me think about some things. But, bottom line is I don't think the prosecutor has a duty or an obligation to make a sweetheart offer. So if he does and the defendant wants to take it, they're not forced to take it. They can say, no, my policy, I'm advising my client, you've got to see the evidence before you plead.
Sure.
And if you're guilty of the lesser offense, well, I'll convict you of that.
I think I'm worried about it in going to offer within a sweetheart offer would be my concern, but that's,
Could I throw this out there too, just to let everybody know, because everybody may not know this, but the Chief Justice has pushed for all districts to have an H&I court in district court. So that is probably going to be more wide.
Something like that. And just, that has the fairness to it.
I think wording is important. When you read the for the first time, yeah, it's icky. Word of the day today. But when you think it through, and then to hear from defense attorneys who say, that's when I get my best offer. And there you come in H&I, and the DA comes in and says, well, who qualify for eviction? If you want to move this today, most defendants are qualified to take it. And it'd be unfortunate for them if they lost it.
Yes, sir.
And I'll shut up in a second, but defense lawyers also have an obligation to engage in their own investigations and discovery. And we're making the assumption here that the defense lawyer has only the prosecutor's discovery to deal with. But, a competent defense attorney will engage in, either through private investigation or otherwise, learn a lot about the facts of the case. And in 95% or more of the cases, the facts are undisputed. And informants are not required to be revealed unless they go to trial and a Rodiero motion is filed and the informant was actually present. They can just be identified as a confidential informant until trial, and only revealed if they were present at the actual deal. But defense attorneys, most of them do a competent, thorough investigation on their own and not rely exclusively on state-provided discovery. But I understand going back to subcommittee, so maybe I'll withdraw my motion to submit this for approval. So I'll do that. I'll follow Brian's lead and then wander off and say good luck.
I think it would really be good to consider whether we should issue this opinion or not. I don't wanna open up, this is just me, I just would not wanna open up a can of worms, like that. If we can,
I'll chime in too. I mean, I'm in the same area. I'm fortunate, I guess, like Karen. I don't have these problems. I've never had this situation come up, believe it or not. I guess if it did, it'd probably shock me. And I'd probably ask the prosecutor to put in writing that they've done their job, comply with 328, and they're not aware. I don't know, it would just shock me if that happened in my district, because they have a prosecutor that reads all the discovery, they make the plea offers, you know, and we negotiate going forward, but I don't know how we change the wording. I'm not sure what we do to change the wording, but when you read it, I've had several.
This is why we're not deciding it, or?
Yeah, usually we just send communication to them saying that it was withdrawn, that the committee determined not to issue an opinion. It's a very kind of vague, like sort of communication. But usually, if somebody calls, I'm trying to think of the last time we did that. I don't know if I had an actual call with the person to explain this is why they decided not to issue the opinion, but we don't go into terrible detail in the letter.
So this may be out of order, but if I wanted to, and it could say on the, can I make a motion that we don't issue an opinion? Or is that premature? Are we still
I mean, that's up to the committee members, but I think as far as the priorities of motion, I think there was a motion to return to subcommittee, but then.
for them to have a discussion.
I see.
Yeah, but we can do whatever the committee pleases.
I think in this situation, to your question, this will be an easy discussion by Brian with the person as to why we didn't issue it.
Yeah.
I mean, the title itself is withholding criminal discovery. I mean, it'd be pretty straightforward.
Is there a motion then to send it to subcommittee, or is it?
I think there is a
But
motion.
he withdrew it.
Oh, he withdrew it.
No, we had a motion to publish it,
To send
and then
council.
withdrew that. Right.
Okay, well, I'd like to make a motion to send it back to the subcommittee.
Second.
All right, we have a motion and a second to send this back to subcommittee. Any other discussion? All those in favor, please say aye. Aye. Any opposed, nay? All right. Yeah, we'll go back to subcommittee. Thanks.
We're gonna miss you.
It's pretty good.
Oh, yes,
Yeah.
we'll figure it out, yes. We'll get you a new subcommittee chair.
We need a chair. Do we need a new member? A replacement member?
Possibly.
Yes, we'll come back to it though. All right, new inquiry of grievance, client consent to annual rate increase.
So this is an inquiry that comes from the grievance committee. They were wrestling with this issue. The opinion essentially addresses a clause in a fee agreement that a client would sign at the outset of representation that essentially allows a firm to increase its hourly rate just on an annual basis. The clause was somewhat vague. I already see a question.
No, I have to recuse. Is this when I do it?
Oh,
I should have done it earlier, but I forgot. this
yes, you
is my
can. Yes.
Okay.
Yes.
Noted, thank you. But yeah, the fee agreement is just kind of this, or the clause that really just has the client consent to an increase in the hourly rate. The hourly rate increase is just implemented without notice to the client, other than that initial notice that this can occur on an annual basis with no proposed cap or anything like that. It's just kind of a, hey, we review our rates every year and they may increase, and when they do, they're just going to show up on your bill and you have to pay for it. And so the opinion goes through and questions whether or not that is an appropriate method for increasing your hourly rate. And the opinion answers no, it's not. Particularly noting that comments to Rule 1.5, particularly Comment 5, says that a lawyer can always seek to renegotiate an hourly rate, but can't simply impose something and threaten to discontinue legal work to essentially get a higher fee. So the opinion goes on to say that essentially there is a way to do this, that you could have a more clear communication at the outset of representation about a proposed fee increase, and that there's an opportunity for the lawyer, or excuse me, for the client to not just receive notice, but then potentially object. Maybe they need to seek additional representation, and especially if there's some sort of, if there's a kind of a limit that's a not clearly excessive increase to the fee, that could be potentially permissible. So, with that said, this is something that, in my humble opinion, I think needs to be discussed in subcommittee. I think this, I don't know how widespread this is. I think it is something that's in place in a number of firms, from what we can tell. And I think that we need to get some input from a variety of different practice areas as to these types of clauses and fee agreements. But that's staff's recommendation.
I would think, just one comment on this, because maybe this impacts me the most. My average case is 5 to 6 years, because I do large nationwide class actions. So this is a really big issue for us, because we're going to be dealing over almost a half a decade to a decade on a case. So when we do our engagement letters, this is something we have to put in there, because obviously we can't agree to hold our fees constant, and obviously we discuss this with the clients and things like that. But I would say, like, this is a very real issue, and I would just encourage the subcommittee that just consider there's a lot of us.
Well, you could find a new lawyer. Like that, I don't agree with that. But I do feel better about, potentially having in your retainer that, hey, we reviewed this, we review our rates after a year, it might increase 2%, 3%. I feel better about that. And so, yeah, I agree with Brian. I do think that it needs to go to subcommittee, and it probably should have people who have cases that are on the longer side, so they can, voice their opinions on how it actually works. But yeah, I'm open to hearing what other folks think, but I think that it should go to subcommittee.
Yes, and one other thing for the subcommittee, just if another version of this sort of is in Social Security disability law, the Social Security Administration sets a fee max that you can charge, so it's 25% of the back pay or the fee max, whichever's less. And that amount, these cases can often last years as well, and that amount can go up sort of intermittently and randomly as Social Security decides to increase it. So, like, it was $5,300 for many years, and then it bumped up to $7,200. Now I think it's going to go up to like $9,200 very quickly, just because of the politics of it. My point is, the way our fee agreement's always read is, your fee will be subject to approval by Social Security, which currently the rate is 25%, or whatever the fee max is then, or the fee max at the time of determination of your case. So it's similar, and I just want to mention that to the subcommittee, a situation where your fee will go up, and we don't necessarily call you up and tell you, maybe we should, but it's not, there's no notice to us. I mean, there is notice, but it's not a regular percentage that we can say, next year it will be this, next year it will be that. And so it's just something to mention to the subcommittee.
And for anybody that's put these provisions in their fee agreements, is that, I've seen a lot of contracts for services outside the legal profession where it's attached to some sort of price index, where it could go up or down based on what the economy is doing or inflation or whatever it is. And I just wonder if that's something should be considered. So not just the law firm unilaterally deciding, hey, I'm going to change my fee on you for $50 or whatever it is. I didn't know if it's like attached to something. Just something to think about.
Any other two for John, Christine?
I agree, and I think it does warrant further study by subcommittee for all the reasons we're talking about. I mean, I don't have this exact language in my fee agreements, but as I read it, I was intrigued by the idea and by the problems that it also presents.
Christine.
Any thoughts, Christina?
Well, we have something similar in our engagement or our one that I can't hear, but yes, I do think that a subcommittee would be a good idea.
All right, so I have a motion by Takia, second by John.
Who are dealing with just horrible circumstances, personal and professional, maybe just kind of get their feet under them and say, well, where do I start? And what are some things that I need to think about with regards to my practice. So you can see in the opinion, there's questions that, or some suggestions to, just kind of think about, all right, outward facing communications. Clients, of course, are wondering what's going on with their cases. And, even if it's just something like updating the website, or if there's an opportunity to update your voicemail message, letting some folks know if they had a case that was pending and now that thing has been continued because the courts were closed. If there's deadlines coming up and those deadlines were extended, just to be aware of those things as well as communicate them. The opinion really, I think we really tried to take the tone that this is not so much the rules require lawyers to do this at this time, because the rules are rules of reason, and that's something that we say at the outset of the opinion, really emphasizing that under these circumstances, lawyers very reasonably should focus on their personal lives and the destruction that they have to recover from. But when you start taking those steps to re-engage with your practice, here's some starting points. And so we put this out here because it is advice that we have published under the name of the State Bar. Like I said, it's not a formal ethics opinion per se, but I did want to pass this through the Ethics Committee to see if there's anything that the committee feels needs to be changed or anything of that nature. But otherwise, staff would request that the committee approve this, and we simply hold on to this as information that we can rely upon if needed.
I think it's great, and I think that it was really good. Actually great that you all went with it so quickly and provided this assistance. Yes, sir.
Yeah, I want to thank you all for being so timely about this. This was something that took immediate direct action on people's lives, and we all took immediate direct action to address that. And thank you. It didn't affect me, but I know numerous people that did. So I think it's wonderful.
Thank you. It was a team effort, for sure.
Y'all have a great team, so that's good. Any other comments? Things on it? Could I have a motion?
Move approval.
Second.
All right, we have a motion to approve this as an ethics advice. All those in favor, please say aye. Aye. Any opposed, say no. All right. Keep doing what you're doing.
All right. Last thing.
Yes, last, proposed 2024 formal ethics opinion 1, use of AI in a law practice.
I just love that we published 2 opinions, and the AI opinion is not the one that received any comment. So here we are. We have for the committee's consideration potential to approve to send to the council for adoption proposed 2024 FEO1, which deals with the lawyer's professional responsibility when using artificial intelligence. Like we said, we published it this past quarter. After it had been through a prior round of publication, and we revised it, but it was published and received no comment from the profession, but a lot of requests to do CLE presentations on this as well. So I guess that would be staff's recommendation to send it to the council for adoption.
I will say that I participated in NCCU School of Law's Law and Tech Summit that recently took place, and we had a lot of discussion about this. And you all got we got kudos for this. So I'm glad to know we're, I think, leading the way, because there's not many places where they actually have some opinion. So, any comments, concerns? Do I have a motion to send this to the council for adoption?
We should send it to the council for adoption.
So moved. Second. All right. It's been proper motion and a second to send this to the council for adoption. Any discussion, any further? All right. All those in favor, please say aye. Aye. Any opposed, nay? All right. It will go to the council for adoption. And that is our full agenda. Since we're with our full agenda, I don't think we need a motion. Thank you, everybody. I hope y'all have a great rest of your day. One more thing.
One more thing, if we can get everyone's attention. This is a bit of bittersweet news, and she's gonna really hate me for doing this, but this is Lanice's last meeting. Lanice is leaving far, but we would be remiss if we didn't look back at her and embarrass her and tell her how much we are going to miss her and how much we appreciate all the work that she has done to make this committee run. So.
Thank you, Leslie.